Welcome to today's Academic Explainer class. Today, we are decoding an absolute cornerstone of property law under the Transfer of Property Act, 1882. Specifically, we are examining Conditions Restraining Alienation under Section 10. Now, listen carefully. For those of you targeting top marks in your KSLU examinations, mastering this exact literature is your key to success. This is a highly technical area of jurisprudence, and evaluators will look for absolute precision. Let us begin our inquiry. Please note down this exact synopsis for your answer script. If you get a 16-mark essay question on this topic, this is your mandatory framework. 1. Introduction and meaning. 2. General rule under Section 10. 3. Types of restraints. 4. When is a condition void? 5. Exceptions to the rule. And finally, 6. Case laws and critical analysis. Do not deviate from this structure in your exams. Moving on. Section 1. Introduction and meaning. On your screen it says, meaning, a condition restraining alienation, is a stipulation in a transfer which restricts the transferee from transferring, selling, gifting, mortgaging, etc., the property. Okay, let's dive into this. The foundational premise of our entire legal system is that the law inherently favors the free transferability of property, right? Property has to circulate within the economy. It is not meant to be tied up indefinitely by the dead hand of past generations. So let's dissect this legal terminology. A stipulation is simply a condition attached to the transfer. Alienation just means transferring ownership rights to another person. So if someone transfers property but adds a rule saying the new owner cannot sell it, gift it, or mortgage it, well, that is a condition restraining alienation. And you must remember, any restriction on this fundamental right is strictly examined under Section 10. Section 2. General rule under Section 10. I need your full attention here. Quoting this specific statutory provision is absolutely critical for the exam. The text reads, Section 10. Every condition that absolutely restrains the transferee from alienating the property is void. The transferee takes the property as if no such restriction exists. Let me elaborate on the legal consequence of this phrasing. The law practically splits the transaction into two distinct parts, the transfer of the property and the condition attached to it. The transfer remains perfectly valid. The transferee becomes the absolute owner. But that restrictive condition, it is entirely struck down by the court. It is void ab initio. The law simply ignores the restriction, as if it were never written. Section 3. Types of restraints. The slide clearly contrasts the two concepts. Absolute restraint, complete prohibition on transfer, e.g., A shall never sell the property. This is void. Versus partial restraint, restriction limited in scope like time, person, or manner. This is valid only if reasonable. And this brilliantly illustrates what KSLU evaluators are looking for. They want clear, structured distinctions in your answer scripts. On one side, absolute restraint is a total roadblock. The consequence is that it's void. On the other side, partial restraint is just a speed bump. It's a limitation by time, person, or manner. The consequence? Valid, but only if the court finds it reasonable. The law simply won't tolerate a complete blockage of property transfer, but it will entertain sensible, limited conditions. Section 4. When is a condition void? Prepare yourselves to list out the exact circumstances that trigger Section 10. The slide lists 4 points. 1. Absolute prohibition, which is a total ban on transfer. 2. Repugnancy to interest created, meaning the transferee is given ownership but denied essential rights. 3. Defeats legal incidence of ownership. 4. Against public policy, because it prevents free circulation in society. You must state these points precisely in your exam. Let's understand the comprehensive reasoning here, class. When you hand someone ownership, the natural rights attached to that ownership must follow. Denying these rights creates a massive contradiction, a repugnancy, in the law itself. Furthermore, if we allowed absolute prohibitions, it would lead to a harmful concentration of wealth, and maintaining the free circulation of wealth is vital for public policy. Section 5. Exceptions to the rule. Let's read the exceptions. 1. Lease or lessee's interest, where restrictions on subletting or assignment may be valid. 2. Benefit of a married woman, where restraints are valid in certain personal law contexts. 3. Reasonable partial restrictions, example, not to sell for a fixed period. Now, as a word of warning, no legal rule is without its exceptions, and this is precisely where students tend to lose precious marks. You must enumerate these clearly. Why does the law permit these specific deviations? Well, in a lease, the landlord actually retains ultimate ownership, right? So they need the commercial flexibility to control who exactly occupies their property.
For the second point, historically, the law sought to protect vulnerable interests. Ensuring property meant for the maintenance of a married woman couldn't just be alienated away. These exceptions cleverly allow for commercial pragmatism and protection without violating the core principle of property circulation.
Section 6. Case Laws and Critical Analysis. We now shift to the absolute climax of any KSLU answer, the judicial precedents. The slide states Rosher v. Rosher, absolute restraint declared void. Let us do a deep breakdown of this landmark precedent. The brief background facts of this case involve a scenario where property is transferred through a will. However, the transferor imposes a strict condition completely prohibiting the new owner from selling the property at its actual market value. So what was the ratio decidendi? The final verdict of the court was exceptionally clear. Such a condition operates practically as an absolute restraint and is therefore entirely void in the eyes of the law. The absolute relevance of this case to Section 10 is that it firmly establishes the boundary of testamentary freedom. You simply cannot give property while legally shackling it. Exam tip class, write this case law in a separate boxed format. You want to make absolutely sure the evaluator cannot miss it. Next on screen, Mohid Raza v. Abbas Bondi Bibi, condition restricting alienation held repugnant and void. Let us unpack this crucial concept of repugnancy, because that is the ratio decidendi here. The factual background centers around a condition attached to a property transfer that restricted alienation to such an extreme degree that it utterly contradicted the very grant of ownership itself. The court ruled that you cannot create an interest in property and then simultaneously attach a condition that is entirely repugnant or contradictory to that very interest. This case provides vital judicial validation for invalidating conditions that deny essential ownership rights. I am strictly commanding you to underline this case name in your script to immediately capture the KSU evaluator's attention for a 10-mark or 16-mark answer. Section 7. Critical Analysis and Conclusion. A top-tier distinction answer must always conclude with a structured critical analysis of the jurisprudence. Let's systematically read the table. Principle, marketability. Societal impact, ensures marketability of property. Principle, wealth. Societal impact, prevents concentration of wealth. Principle, flexibility. Societal impact, allows flexibility through reasonable restrictions. As future lawyers, you must understand how this law perfectly balances the absolute incidence of individual ownership with the broader societal need for free-flowing property. Absolute restraints are struck down because society literally needs wealth to circulate to survive. But the law brilliantly remains flexible enough to allow reasonable limitations when commercial or personal necessity demands it. If ownership inherently includes the absolute right to transfer, can any partial restriction truly be enforced without fundamentally altering the nature of property itself? I will leave you with this concluding theoretical tension. This is the debate at the very heart of Section 10 jurisprudence. The law attempts to draw a pragmatic, workable line between absolute and partial. But the deep philosophical question remains. Ponder the theoretical depth as you finalize your exam preparation. Remember to ensure your structural headings are clear, box your case laws, and focus heavily on precise statutory language. Class dismissed.